All right, let's talk about one of the trickiest parts of litigation, and a topic you absolutely have to know for the bar exam, non-party discovery. We're going to break down how you can legally get your hands on evidence that could win your case, even when it's held by someone who isn't even part of the lawsuit. Let's jump right in. So picture this. You're deep in a case, and you just know that smoking gun document is out there. Maybe it's a contract, an email, some key financial record. The problem? Your opponent doesn't have it. It's sitting with a bank or an accountant or some other company that has nothing to do with your case. What's your move? Well, you don't just ask nicely. The federal court rules give you a specific playbook, and that's what we're going to walk through right now.
So here's our game plan. First, we'll quickly frame the non-party problem. Then we'll go through the 4 essential steps: how you apply, what the non-party has to do, how you actually get the documents, and what happens when the court has to step in. And then we'll wrap it all up with some key takeaways you can bank for the bar exam.
Okay, let's set the scene. Why are there all these specific rules? Well, it's because getting evidence from an outsider, someone who isn't the plaintiff or the defendant, is a big deal. You're dragging them into a fight that isn't theirs. So the process has to be really careful and really targeted. Before you can even think about starting this process, you have to pass a basic test. The documents you're chasing must be directly relevant to an issue that's already in dispute in the case. This isn't a fishing expedition, right? You can't just cast a wide net and see what you catch. The court needs to see that your request is precise and necessary.
So, you've got a precise request. How do you actually make it happen? That brings us to step 1, the application itself. And the rule you absolutely have to burn into your memory is Rule 20.23. Honestly, just think of 20.23 as the key that unlocks the whole non-party discovery process.
So, Rule 20.23, Subrule 1. This is your power source. It's what lets you go to the court and ask for an order that forces a non-party to tell you what documents they have. And notice that wording. This first step isn't about getting the documents themselves, not yet. It's just about getting a list of what they've got. Now, to make that application, Rule 20.23, Subrule 2, gives you a strict, non-negotiable checklist. You have to serve the application personally on the non-party. You've got to back it up with a sworn affidavit that explains why you think they have these documents. And again, you have to be super precise about what you're asking for. You mess up any one of these steps and your application is dead on arrival. And here's a massive exam tip for you. In your answer, you need to show you understand that courts are really careful about this. They use this power with a lot of caution. You have to prove you've already tried to get the documents from the other side. And this is the big one, you usually have to convince the judge that the non-party is probably the only place you can get this evidence. It's a really high bar to clear.
This quote from Justice Pink just nails it. Think about it from their perspective. They don't want to get tangled up in your legal battle. It's a huge, expensive hassle for them. And because the courts understand this burden, the rules have some really strong protections built in for these third parties, especially when it comes to money.
Okay, so let's say you did everything right, and you got your order under 2023. Awesome. Now, let's flip the coin and look at it from the non-party's perspective. What do they have to do, and what are their rights? It's all about balance. The rules create this really clear trade-off. On one side, you have Rule 20.24, which imposes a duty. If the court makes an order, the non-party must comply and give you that list of documents. But on the other side, you have Rule 20.25, which gives them a massive right. They can go to the court and ask for an order, making you pay for all their costs and expenses.
This is a point you have to commit to memory. Remember Rule 2025. A non-party has what's called a prima facie entitlement to get their reasonable costs back. That just means, on the face of it, the court's default position is that an innocent third party should not have to pay a single cent to get involved in someone else's lawsuit.
Okay, so the non-party has given you their list, you scan down it, and there it is, the document you need. So how do you actually get it in your hands? This is where we move from discovery, getting the list, to production, getting the goods. And again, the rules are different for parties versus non-parties.
And just look at the difference here. If you want documents from another party in the lawsuit, that's Rule 2031. You just serve a simple notice to produce. It's basically paperwork. But for a non-party, that's Rule 2033. If they drag their feet or refuse to let you see the documents, you have to go back to court and get a whole separate order for production. It's a much bigger deal.
So what happens when things get messy? What if the non-party puts a document on the list, but then says, actually, you can't see this, it's privileged? This is where the court plays its role as the final referee, the ultimate backstop to sort out any fights over production.
And the court has a really powerful tool up its sleeve to do this. Rule 2035, Sub-Rule 2. If a non-party claims a document is protected by legal privilege, the judge doesn't just have to take their word for it. The judge can literally say, "Give it to me," and inspect the document privately to decide if that privilege claim is legit. It's how the system ensures no one is hiding relevant evidence behind a bogus claim.
Okay, we've walked through the whole process. Now let's do a rapid-fire review to lock these rule numbers in your brain. This is the stuff you absolutely need to have down cold for your exam. Ready?
First up, Rule 2023. This is your starting block. 20.23 is how you apply. It gets the ball rolling.
Next, the non-party's position. It's a two-parter. Rule 20.24 is their duty to give you the list, and Rule 20.25 is their right to get paid for it. 20.24 and 20.25. Duty and right. Easy.
Now, let's talk about getting the actual documents. Rule 20.31 is the easy one. That's for getting documents from a party. You just send them a notice.
But for a non-party, it's tougher. That's Rule 20.33. You need to go back and get a court order. So remember that difference. 20.31 is a party notice. 20.33 is a non-party order.
And finally, Rule 20.35. That's the court's ultimate power. When there's a dispute over privilege, the court inspects the document. That's Rule 20.35. And there you have it. That's your roadmap for non-party discovery. Look, it's more than just a bunch of rule numbers to memorize. This is the actual framework you're going to use to uncover the truth and build a winning argument. They say procedure is the skeleton of justice. Well, these rules are the bones. The real question is, how are you going to use them to build your case?